Welcome to the Secrets of Personal Injury Law with Colin Bober.
Hello and welcome to The Secrets of Personal Injury Law with Colin Bober. Colin is a personal injury attorney who has represented over 4,000 clients with a gross settlement recovery of over $50 million. I am your host, Kevin Rosenquist, and today's episode is In the Hot Seat, Unpacking Negligence in Personal Injury Law. Colin, so good to see you again.
Yeah, man. Glad to be here.
Yeah, for sure. So can you start by explaining what negligence means in the context of personal injury law and how it factors into the success of a case?
Yeah, negligence has four parts, four elements that have to be met before anybody has any liability. The first one is you have to define what somebody's duty was. So when it comes to a car accident, it is the duty to drive your vehicle in a responsible, prudent manner. There's a breach of that duty, which is the breach of basically running into somebody. You're not supposed to do that. That breach of that duty caused an injury that you're now complaining of, which is why you're receiving medical care. And those medical bills that you incur are your damages that you have to be able to present to an insurance company or a jury to be compensated.
How do these elements vary depending on the type of case?
Well, the most common case that we see are people just not paying attention, being on their cell phones, and they just rear end somebody. It doesn't have to be a very overt act. It's just a simple, oops, I just ran into the back of you, I'm sorry. And now you have somebody with an injury. It's very simple, or it can be very complex, where somebody didn't operate their vehicle at all, or lost control of their vehicle, or a tire came off, so it wasn't really their fault. It was somebody else's fault for not putting the tire on. It can be very complex, but the premise of negligence is just the breach of a duty that caused an injury, that caused or brought damages to calculate and be compensated.
What other areas of personal injury will you see negligence in, and what types of negligence will you see?
Well, personal injury in itself is very broad. I mean, obviously you can tell that, but most people do car accidents, and then there are slip and falls. But the application of slip and falls is still the same. Somebody put something on the floor, it wasn't supposed to be there. That's a breach of their duty. Somebody slipped and fell, incurred medical expenses and damages. And it's the same model, it's just a different application. Or you have medical malpractice, where you have a doctor that was supposed to do the procedure one way. They didn't do that way, and it caused an injury and incurred additional medical bills. So the application is still the same. The personal injury world specializes into basically those four parts.
Okay. What kind of evidence is typically required to support a negligent claim?
Most people understand the fundamental part of everybody has a duty to just do things you're supposed to, drive your vehicle a certain way, operate under a certain level, professionalism when it comes to being a doctor, keeping floors clean, things like that. People understand the duty part. But when it comes to the breach, you sometimes get into a chain of command issue, a chain of custody issue about who was responsible to clean the floor, or who was responsible for providing this device that caused this injury. So you have to find out who is the actual responsible party to be compensated. And then sometimes that gets a little more complex.
How do you go about doing that?
So basically, when it comes to litigation, which is generally how these issues turn out, I mean, it's simply if the person who caused the injury just says, yep, I did it, it's a breeze, right? Now we're just talking about compensation. But if you have people pointing fingers at each other, even at a multi-car accident, well, you hit me first, no, you hit me first, those kind of things, then we end up getting into litigation and getting these potential at-fault parties to testify under oath so we can really unpack the story. And it's the same thing about deposing a doctor or a store manager. You really got to get that testimony from anybody who was there as a witness, who had custody of whatever the situation was, whether it was a medical procedure, a store, floor, whatever it was. You just pull everybody in and get testimony from them in some kind of deposition or a written statement and try and unpack what the story actually was.
Is it difficult to, depending on how long it's been since the accident, it could be difficult to be able to get all those people together to do your depositions, right?
Yes. And that's why we had talked about a few episodes ago about really understanding your environment. If you have any cameras, whether it's an exterior camera from a store or anybody around you that may have seen it, that we want you to collect that stuff at the beginning. You may not think it's relevant at the time, but if it drags on for 6 months, people get forgetful.
That's what I was thinking. Yeah.
Right. Right. So you really have, and it's hard. And I understand it from a personal point of view. If you've been injured in any way, that's not what you're thinking about.
Right.
But you have to think about it. And that's why I love doing these podcasts, because it gives you that information before it happens. Right. So you got to gather all that information so that you can present that to somebody you want to advocate for you to get the compensation that you're looking for.
How important is it to get to you early?
It's very important depending on what the facts are. For instance, say you're in an accident, in a car accident, and the accident occurs next to like a Wendy's, right? And you don't have any witnesses, nobody was there. The only thing that you have is potentially a camera that saw the street that the accident occurred on. Well, normally those exterior cameras, that data rolls over after 30 days. So if you don't have any witnesses at all, depending on the retention time of that data alone, you may not have anything to prove that an accident even occurred. And when it comes to the injury part, insurance companies, whether they're wrong or right, and I think they're always wrong, but basically their first argument to you is, as an attorney, well, if your client was really injured, then they would have gone to seek treatment right away, but they waited 4 weeks to do it. But they don't take into consideration that medical treatment is an out-of-pocket expense. A lot of people don't have any health insurance. They don't even know who they go to see, because some doctors will say, yeah, if you're in an accident, we're not gonna see you, because we don't always get reimbursed by insurance for things that are caused by an accident, because they want the at-fault party's insurance to pay the bill, right? So people don't know that they don't know what their options are, which creates the delay. And that's why, at least as an attorney, we can give them advice on the best way to approach that.
Okay. Yeah. And can you explain the concept of comparative negligence, as far as, both parties might share responsibility for an accident or injury?
Yeah. So a lot of times, it happens a lot in multi-car accidents where one person hits another person who hits another person. There are two other people at fault, right? There are two people at fault, and they're both pointing fingers at each other. So Texas has a comparative negligence position, which basically says if you're found by a jury to be over 51%, you recover nothing. If you're 50-50, you get 50% of your damages. But if you're over 50, you don't get anything.
Wow.
Right. And so that's why it's really important to gather that data, so you can get the testimony from everybody involved to say who's really at fault, because both parties are saying we're both equally at fault. Maybe you are, maybe you're not. But we have to be able to do the discovery and get the information to find out for sure.
So in a situation, if me and you are involved in a car accident and I'm 51% at fault and you're 49% at fault, I get nothing and you get a full reward?
I get 49% of whatever I'm claiming, because I still have some negligence. The point is, if you have more negligence than me, over that 50% threshold, you don't get anything. It doesn't mean that now you're all of a sudden fully at fault. It just means that I get my portion, but you don't, because you're more at fault than I am, over 50%.
Okay. Got it. Those have got to be tough cases to prove, right?
Yeah. Usually it doesn't come down to a 49-51. Usually it's like 75-25, It's very obvious. And if that's the case, you're very clearly at fault for the most part. So it usually doesn't come down to the weeds like that, but it's possible.
So then in a case like that with 75-25, does the 25 person, do they essentially get 75% of their claim?
Yes.
Yeah. Okay. Got it. That's what I thought. All right. How does the severity of an injury influence the way negligence is proven or argued in court, particularly in cases involving maybe long-term or life-changing injuries?
The negligence has to be proven first on a factual matter. It doesn't have any correlation to the severity of the injury.
Okay.
Once you establish the duty, the breach, the damages, and the causal link between the two, that part is established and done. So now you're looking at testimony from doctors or experts that are saying, yes, the client incurred X $1,000 in medical expenses, but the medical expenses aren't the whole story. You have economic damages, which are the dollar figure of the medical bills, plus lost wages and things like that, and the general damages of pain and suffering, mental anguish, loss of consortium, which are not easily calculated. You can't put a number on pain and suffering. It's kind of subjective. So the severity of the injury is where that comes in. I have a dollar figure of how much I owe in expenses, but I have another figure in general damages, and I'm going to have these injuries for the rest of my life, which is this sum of money. right? So once negligence is established, we're good. Now we're just talking about a dollar figure that's going to make the plaintiff whole in the eyes of the law. And unfortunately, that's done monetarily. And, the truth of the matter is there's never enough money to make somebody the same, because nobody is the same after an accident, which is why we leave it up to a jury to decide. So they get to decide all the factors and how long it'll take to recover and things like that, to come up with a number that is agreeable and will get the case settled.
When negligence is involved like this, like what we're talking about for this episode, does it change the way that the whole process works? Because I know, like, obviously there's plenty of room to, there's places to settle along the way. Does settling happen the same way? Does mediation happen the same way? Or in these situations, is it different?
Well, at the beginning, it's always a fight. When you open a claim, the insurance company is paid to tell you no, right? And so a lot of times we'll get a situation where they're like, yeah, our guy didn't do it. And we're like, okay. And we can't tell them prove it, because the burden of proof is on us.
Right.
So the only option we have is to file a lawsuit, collect all the evidence, and show then not only based on witness testimony that we believe that a jury would find that your person is at fault, but then we also go a step further and do a background check on the potential defendant and say, not only do we think, or based on this information, it shows that they might be at fault, they also have a terrible background, which shows that they have a lack of credibility. Mm-hmm. And all of a sudden, like I had mentioned in a previous podcast, for insurance, it's just a business decision. For them, they just want to pay money to make it go away, because if it gets in the hands of a jury, they may award an exorbitant amount of money, and then the insurance company likely has to pay it. So that's the sad reality of insurance, is to them, it's just business. How much do I need to pay to make this thing go away? And that's when you have to put everything together, make sure that the defendant, if they look bad, present them as a bad witness. If you have the damage model that says you're going to have an injury for the rest of your life, present that. And then once we get into that stage, it's a lot easier to make the argument about recovery, because they don't want to roll the dice with a bad witness on the stand.
Yeah. As far as Texas law goes, is there a cap? I think was it called tort laws? Is there a cap that goes on the amount that a jury can award?
Not that I'm aware of. Okay. I don't believe that they have reached a cap on economic damages, because the part of the reason that it's relatively limited, the only limitation that I've found so far is that the reality is, when it comes to an insurance claim, you're usually bound by the limits of the policy. So a lot of clients will say, well, how much am I going to get? You could go get a jury verdict for $1 million. But there's also another practical aspect. Okay, I have a verdict for $1 million. How am I going to get it? The insurance company, 95% of the time, is only responsible for the amount covered under the policy, as long as they don't blow it. And, it's a little more technical than that. It is possible to get a jury verdict over the policy limit where the insurance company has to pay. But if the insurance company forks over the policy limit of $30,000 and says, yep, we're at fault, we're good, we're absolving our liability of $30,000, you can still sue, but the insurance company's out of it. So if you go get the remainder of the $1 million from the defendant from a jury verdict, you got a piece of paper, but they don't have any assets to collect them.
Yeah, I was going to say they don't have the money.
That's the hard line of PI, or personal injury, is I'm all for making sure that these people are fully compensated, but there's also some realism and expectations in terms of, it's not really a question of how much am I going to recover, it's more so or less so, how much am I going to get, but what am I actually going to be able to recover in practicality.
Right. What are some of the biggest challenges you face when trying to prove negligence in personal injury cases, and how do you overcome them to secure favorable outcomes?
Like I said, it's funny from an insurance perspective, because these insurance companies, it seems like they just read from a script, right? Because after so many cases, I'm like, yeah, go through your script. I've already heard it before. As soon as you're done, let me know. We'll talk about it when you're done. And so, they're just checking a box. And
fast forward a little bit. I know you just say it along with them.
yeah, just same verbiage. And I'm like, listen, you can make your business decision whichever way you want to, but at the end of the day, if you make the wrong decision, I have to sue your insurer. And that it's not really a threat. That is the only option.
Right. That's a fact. Yeah.
Yeah. And so then they come back and say, well, okay, we're going to defend it vigorously. Okay. Well, that is also a fact, because that's your contractual obligation. So it makes it sound like we're fighting, but we're just stating the obvious. Right. And that once you get that in your mindset of that's how it works, it's really not a scary adventure. Right. And so that it's the hard part is trying to get it resolved without having to escalate it, because It takes time and it takes money. So that's why when in evidence collection, whether it's, a background check on the defendant to show whether they'll be a poor witness or whether it's a witness statement, because a lot of times people, when they get in an accident, the insurance company is required to get a statement from their own driver who caused it, right? And every time it seems to be that they're like, yeah, I didn't hit anybody. I was never in an accident. Because I remember we had one where a defendant said, I didn't even touch that lady. Never did. And so they denied it initially, but the client was smart enough. She took a picture of his blue Corvette that stuck out like a sore thumb with the license plate on it. So we sent it back into the insurance company and said, is this your guy? Because it looks like your guy. And then all of a sudden here they come with all this money. And so that's what it's all about. That's a perfect illustration of what it's all about. The insurance company's job is to tell you no, and you have to collect the information to be like, you're wrong, and here's why. If you don't have anything to show, then you're going to have a really hard time.
Yeah. The gamesmanship of it all.
Yeah. It's a big chess game.
Yeah. All right. Interesting stuff. All right. Well, thank you for tuning in to The Secrets of Personal Injury Law with Colin Bober. To connect with Colin and his team, visit boberlawfirm.com, and please like and subscribe to our channel and leave us a review. Colin, always great to see you. Looking forward to the next one.
Thank you for the time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.